South Carolina's lease termination laws are governed by the South Carolina Residential Landlord and Tenant Act, found in South Carolina Code Title 27, Chapter 40. The framework is moderately landlord-friendly while still providing tenants with meaningful protections, and the process is straightforward if you follow the steps correctly. Let's start with no-cause termination. For month-to-month tenancies, South Carolina requires either party to provide at least 30 days written notice before the end of the rental period. The notice must expire at the end of a monthly rental period, so timing matters. If rent is due on the 1st and you want the tenancy to end on March 31st, you need to deliver notice by March 1st at the latest, and ideally a few days earlier to ensure it's received in time. For fixed-term leases, the lease expires at the end of the agreed term. South Carolina does not require additional notice to terminate a fixed-term lease at its natural expiration unless the lease itself includes a notice requirement. If the tenant remains after the lease expires and the landlord accepts rent, the tenancy generally converts to a month-to-month arrangement on the same terms. For week-to-week tenancies, 7 days' notice is required from either party. Now let's cover termination for cause. For non-payment of rent, South Carolina requires the landlord to provide a 5-day written notice demanding payment before filing for eviction. Under Section 27-40-710, the landlord must give the tenant 5 days to pay the full amount of rent owed. If the tenant pays within that window, the notice is void and the tenancy continues. If the tenant doesn't pay, the landlord can proceed with filing an ejectment action in magistrate court. South Carolina's 5-day non-payment window is relatively short and gives landlords the ability to act fairly quickly when rent goes unpaid. But precision matters. The 5 days must be calculated correctly, and the notice must clearly state the amount owed and the deadline for payment. For lease violations other than non-payment, South Carolina uses a 14-day notice to cure, followed by a 30-day termination timeline. Under Section 27-40-710, the landlord must provide written notice specifying the violation and informing the tenant that the rental agreement will terminate in not less than 30 days if the breach is not remedied within 14 days. If the tenant corrects the violation within 14 days, the termination is canceled. If the tenant fails to cure, the tenancy ends at the 30-day mark. For repeated violations, South Carolina has an important provision. If the same type of violation recurs within 6 months of a prior notice, the landlord can terminate the rental agreement with 14 days written notice, this time without offering another opportunity to cure. This escalation mechanism prevents tenants from repeatedly committing and curing the same violation. For violations that pose an imminent threat to health or safety, including serious criminal activity, drug manufacturing or distribution, or violent conduct on the premises, South Carolina allows expedited proceedings. The landlord can seek immediate relief through the courts, and judges have discretion to schedule hearings on a shortened timeline when the circumstances warrant it. South Carolina also addresses situations involving substantial damage to the property. If a tenant deliberately or recklessly destroys, defaces, or damages the premises, or removes a portion of the premises, the landlord can terminate the rental agreement and pursue eviction along with damages. One aspect of South Carolina law that landlords should understand is the concept of constructive eviction as it relates to tenant-initiated termination. If a landlord fails to maintain the property and conditions deteriorate to the point where the unit is essentially unlivable, the tenant may be able to claim constructive eviction and terminate the lease without penalty. However, the tenant must actually vacate the premises within a reasonable time of the conditions becoming intolerable. A tenant who continues living in the unit while claiming it's uninhabitable will have a harder time making this argument in court. On the tenant side, South Carolina provides several grounds for early termination. If the landlord fails to maintain the property in a fit and habitable condition, as we covered in our South Carolina habitability video, the tenant can provide written notice and allow the landlord 14 days to make the repair. If the landlord doesn't act, the tenant can terminate the lease. Active duty military members are protected by the Federal Service Members Civil Relief Act and can terminate with 30 days' notice following deployment or permanent change of station orders. South Carolina enacted the Safe Home Act, which provides early termination rights for tenants who are victims of domestic violence. Under this law, a tenant who has obtained a valid order of protection or who has filed a police report documenting domestic violence can terminate the lease by providing written notice to the landlord. The tenant must provide at least 30 days' notice and is responsible for rent through the termination date. The landlord cannot impose early termination penalties or report the early termination as negative rental history. South Carolina also provides protections for tenants who are victims of sexual assault and stalking under the same framework. The documentation and notice requirements are similar to those for domestic violence situations. South Carolina strictly prohibits self-help evictions. Under Section 27-40-660, landlords cannot change locks, shut off utilities, remove doors or windows, or take any action to force a tenant out without going through the court system. A landlord who engages in self-help eviction can be held liable for up to 3 months' rent or twice the actual damages, whichever is greater, plus attorney's fees. This penalty is significant and should deter any landlord from attempting to bypass the legal process. The eviction process in South Carolina goes through the magistrate court in the county where the property is located. The landlord files an ejectment action, and the court issues a rule to show cause. Essentially, a summons requiring the tenant to appear and explain why they shouldn't be removed. The hearing is typically scheduled within 7 to 14 days of filing. If the court rules in the landlord's favor, a writ of ejectment is issued, and the sheriff or constable carries out the eviction. South Carolina's court process is generally efficient for landlords. Straightforward non-payment cases can move from filing to physical removal in roughly 3 to 5 weeks. Contested cases, where the tenant raises defenses like habitability issues or improper notice, can take longer, but the magistrate court system is designed to handle these matters relatively quickly. One practical tip for South Carolina landlords: document everything from the moment a lease violation or non-payment issue arises. Keep copies of all notices, photograph the condition of the property, save all communications with the tenant, and note the dates and times of every interaction. South Carolina courts rely heavily on documentation when evaluating landlord-tenant disputes, and a well-organized file can make the difference between winning and losing your case. South Carolina requires landlords to return the security deposit within 30 days of the tenant vacating the property. The landlord must provide an itemized list of any deductions along with the remaining balance. If the landlord fails to return the deposit or provide the itemization within 30 days, they may forfeit the right to retain any portion of the deposit and could be liable for up to 3 times the amount wrongfully withheld, plus attorney's fees. For the complete guide to South Carolina lease termination laws, visit tenantscreeningbackgroundcheck.com and subscribe to our channel for every state in our series.